Good morning, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina's oral argument in docket number, what is the docket number? It's not on here. 220, is it 229E? Docket number 2020-229E. This is Dominion Energy South Carolina Incorporated's establishment of a solar choice metering tariff pursuant to South Carolina Code, annotated section 58-40-20. We're here today on Dominion's motion to strike witnesses. Before we begin, we're going to take roll. Here in the hearing room, we have Commissioner Caston, Vice Chair Belzer, and Chairman Williams. Joining us virtually, we have Commissioners Powers, Thomas, and Williams. For the record, Commissioner Irvin is recused. Let's take appearances from the parties. Dominion Energy South Carolina.
Mr. Chairman, this is Matt Gissendanner on behalf of Dominion Energy South Carolina, and with me today is Chad Burgess.
All right. Office of Regulatory Staff.
Good morning, Mr. Chairman. Jenny Pittman for ORS.
Frank Knapp, Jr.
Good morning, Mr. Chairman. I am with you this morning.
All right. South Carolina Coastal Conservation League and Southern Alliance for Clean Energy, along with Upstate Forever.
Good morning, Mr. Chairman. This is Kate Mixon appearing on behalf of Southern Alliance for Clean Energy, South Carolina Coastal Conservation League, and Upstate Forever. And also appearing with me here today is David Neal, who has been admitted pro hoc vice in this proceeding.
All right. North Carolina Sustainable Energy Association.
Good morning, Mr. Chairman. Jeff Kirkendall for North Carolina Sustainable Energy Association. I have with me Peter Ledford, who has also been admitted pro hoc vice for this proceeding.
Vote Solar.
Good morning, Mr. Commissioner. Bess Durant on behalf of Vote Solar.
Alder Energy Systems.
Taylor Spear for Alder Energy. Good morning, Mr. Chairman.
Good morning. All right, are there any preliminary matters we need to take up before we proceed? All right, hearing none. Applicant, tell us why we are here today.
Thank you, Mr. Chairman. Matthew Gissendanner on behalf of Dominion Energy South Carolina. I appreciate the opportunity to present the company's argument in this matter. On January 14th, 2021, the Commission issued a revised notice for tomorrow's virtual public hearing, stating in bold and all capital letters, this is a hearing for customers of Dominion Energy South Carolina Incorporated. The two questions before the Commission today are simple and straightforward and may be stated as follows. First, may persons who are not customers of Dominion Energy present testimony or evidence in a proceeding at a hearing that the Commission clearly established and plainly noticed for Dominion Energy customers. And second, at tomorrow's hearing for customers, may solar entities and advocacy groups circumvent Commission rules and regulations, specifically Regulation 103-805B, and introduce evidence through the public testimony of their employees. Dominion Energy asserts that the law and past Commission practice clearly establish that the answer to both questions is no. How you answer these questions will determine whether individuals and companies continue to respect and follow Commission rules and regulations in future dockets. On the first question, the revised notice is clear that the hearing is for customers of Dominion Energy South Carolina, and our opponents concede this point. Dominion Energy has been clear that any customer, even those with ties to the solar industry, may testify, but the commission should not allow persons who are not customers to present testimony or evidence in tomorrow's public hearing. The company objected to 23 names of planned witnesses and asked that they be stricken because they are not customers. That is, they are not listed as an account holder or as a person authorized to transact business on the account. And this is not, as the subsidy supporters argue, the company's own overly technical definition. This is in fact the same standard that the General Assembly applied to define customer in South Carolina Code Annotated 58.3.230, one of the statutes that governs this commission. These individuals are the only individuals responsible for the account and with whom the company has a customer relationship. And unless an individual meets this criteria, he or she has no standing to appear before this commission as a customer of the company. The commission has previously held that persons who are not customers do not have standing to participate in proceedings as a party of record, and they should not be allowed to circumvent the standing requirement by presenting testimony and evidence in this portion of the proceeding that the commission has clearly established for Dominion customers. Because the 23 names identified by Dominion Energy in its March 10th filing are not customers, their names should be stricken from the witness list. In addition to asking that the names be stricken from the witness list, the company has also requested that all witnesses be instructed that they may not testify on behalf of any entity with which they may be affiliated. Individuals may testify only on behalf of himself or herself. Commission Regulation 805B is clear that individuals may not represent solar entities and advocacy groups before the commission, and subsidy supporters do not even attempt to address the effect of this regulation in their response. Moreover, the requested instruction is entirely consistent with the commission's rulings in prior public hearings. To be absolutely clear, Dominion has not and does not suggest that individuals must hire an attorney to provide testimony at a public hearing. What Dominion is maintaining is that the solar entities and advocacy groups with whom these planned witnesses are affiliated must follow the law and hire attorneys to represent them and make their case in proceedings before the commission, instead of trying to make their case through their employees testifying as public witnesses. On this point, it is critical for you to recognize the strategy being employed by the solar industry for this public hearing. As indicated in our March 10th filing, many planned witnesses appear to be affiliated with solar entities and advocacy groups, including Sunrun, a publicly traded company with a market capitalization at one point last week of approximately $11.5 billion. These entities freely chose to not participate in the proceeding under established commission rules and regulations. Intervention would subject the intervening party to discovery, responsive rebuttal testimony from the company, and prepared cross-examination of the intervening party's witnesses. To avoid that, what Sunrun and others have chosen to do is to hijack tomorrow's public hearing and have their employees, many of whom are not Dominion customers, make their case for them in a portion of the proceeding that the commission has specifically reserved for the company's customers. Having chosen not to participate in the way allowed under commission regulations, these entities cannot now be allowed to introduce evidence into the record through the testimony of employees. Sunrun's conduct is particularly egregious for the reasons pointed out in our supplemental reply. In addition to at least 4 non-customer employees scheduled to testify, Sunrun has also sent blatantly and demonstrably false propaganda via an email to Dominion Solar customers and encouraged them to testify based on that misinformation. We have provided a copy of that email to you in our supplemental reply, and I assume you have it in front of you. Dominion Energy has no concerns with its customers having their voices heard. However, Dominion is concerned that the solar industry is willfully spreading demonstrably false information to our customers. The harms of sanctioning the solar industry strategy and conduct in this proceeding are twofold. First, it signals to other entities and individuals that the Commission's rules and regulations do not have to be respected or followed. It renders the revised notice and other procedural protections afforded the company and other parties meaningless and serves to encourage other companies to do the same in future proceedings. And perhaps most harmful is an effect that the industry strategy likely has already had. In fact, it is likely the intended effect of the strategy itself, and that is to discourage and ensure that the voices of those average non-participating customers are not heard at the hearing tomorrow. Obviously, a large portion of the Dominion Energy customer base in South Carolina cannot afford rooftop solar. For many such customers, this hearing tomorrow was the one opportunity to tell you how these rooftop solar subsidies affect them. But as a result of Sunrun and its allies' conduct here, it is almost certain that many average non-participating customers are effectively being drowned out and discouraged from participating. Take Ananta Gopalan from Bluffton, South Carolina. Mr. Gopalan filed a protest letter in February. It's on the Commission's docket system as being accepted for processing on February 24th. Mr. Gopalan indicated that he would be unable to testify at the scheduled date and time, but urged the Commission to reject the company's proposal. Not because it went too far in eliminating the cost shift, but because, quote, it only goes part way in eliminating the subsidy. While the company may disagree with Mr. Gopalan on whether the tariff should be approved, and while Mr. Gopalan may have had a problem with the date regardless of the solar industry's conduct, the real question is how many Ananta Gopalans among Dominion's 750,000 customers without solar may have testified but have been discouraged from doing so because the solar industry flooded the time slots with non-customer employees or non-customer members of advocacy groups or customers who are only scheduled to testify on behalf of the entity with which they are affiliated. Finally, I want to briefly respond to certain arguments made by the subsidy supporters in their response. After subsidy supporters concede that the notice was specifically addressed to customers of Dominion Energy South Carolina, they then proceed to make a series of staggering arguments, each more unbelievable than the previous one, and each designed to distract the Commission from its focus on actual customers of the company. First, we have the mistaken belief that, quote, just because Dominion has identified a customer's name in its billing system, there should not be a presumption that the individual is not a Dominion customer. This erroneous claim is based on the equally erroneous assertion that a person can be a customer of Dominion's electric utility even if that person's name is not on the account. As discussed earlier, this argument runs counter to the General Assembly's own definition of a customer and is simply wrong, because unless an individual is listed on the account as either the account holder or a person authorized to transact business regarding the account, for example, a spouse or a roommate may be listed as an authorized person, the company has no relationship with that individual. Next, we have the hypothetical case of an individual who is not a customer at this time, but who may nevertheless have a reasonable expectation of being a Dominion customer in the future. Subsidy supporters argue that this individual should also be allowed to testify at the hearing that they admit was noticed for Dominion customers. The effect of this argument, of course, would mean that anyone in the world who might possibly take service from Dominion at any point in the future would be allowed to testify and offer evidence in this proceeding, or for that matter, in any other proceeding noticed for customers for Dominion or any other utility. For example, under subsidy supporters' rationale, an individual attending college in the upstate but who might expect to move to Columbia or perhaps Myrtle Beach upon graduation could simultaneously testify in proceedings for customers of Duke Energy Carolinas, Dominion Energy South Carolina, and Duke Energy Progress. That is absurd. Notably, among the 23 planned witness names objected to by Dominion, the subsidy supporters do not identify any individuals who satisfy this greatly expanded and novel criteria for who qualifies as a customer. Finally, we are told that any and all South Carolinians who wish to provide their input in the pending matter should be allowed to testify and provide evidence in a hearing that the Commission has specifically stated is for Dominion customers. If the Commission adopts this position, then it would swing the doors wide open for non-customers to provide sworn testimony and evidence in any other proceeding in which a public hearing is held, and allow non-customers to avoid possessing the requisite of standing before participating in a proceeding. The revised notice's plain statement that this is a hearing for Dominion's customers is sufficient in and of itself to demonstrate the baseless, self-serving nature of the subsidy supporters' arguments here. But even more evidence exists demonstrating that the concern for the Commission at tomorrow's hearing has always been about the company's existing customers, all 760,000 of them. Specifically, the Commission order granting tomorrow's public hearing directed the company to provide notice of the hearing to its customers via a billing insert, which is only sent to customers, and indicated that the notice was necessary so that existing customer generators would have adequate notice of how they will be impacted by these changes. Again, the concern for this Commission at tomorrow's hearing has always been about the company's customers. At no point did the Commission indicate that tomorrow's hearing was to hear from non-Dominion customers, to hear from the solar industry, or to hear from the public at large. The Commission did not require the company to publish the notice in newspapers throughout the state or even throughout its service territory so that anyone with a speculative, conjectural, or hypothetical interest in the proceeding might offer testimony and evidence at tomorrow's hearing. In sum, it is indisputable that the hearing tomorrow is for Dominion's actual customers, not for the solar industry to surreptitiously relitigate its case through non-customer public witnesses or through customers affiliated with solar entities and advocacy groups testifying on their behalf. Solar entities and advocacy groups had ample opportunity to intervene and chose not to do so. Their interests were adequately represented before the Commission by the subsidy supporters, and Dominion's request is in no way inconsistent with Act 62. Dominion respectfully requests that the Commission strike from the witness list the 23 individuals identified in its March 10th filing unless they are willing to affirm under oath that they are a Dominion customer, and that the Commission instruct each witness that he or she may only testify on his or her own behalf and not on behalf of any other entity with which he or she may be affiliated. Finally, since the filing of our motion, we have identified several other individuals who also appear to not be electric customers of the company, and we would ask that the Commission strike them from the list for the same reasons. Based on the list provided by the Commission last Friday, those witnesses are witness number 28, Mr. Russo, who is a gas-only customer of the company.
Mr. Chairman, Mr. Chairman, I would ask that council not identify any names.
Okay, I will simply list the numbers. The witnesses are witness number 28, and this is on the list from last Friday, witness number 28, witness number 80, witness number 81, witness number 83, witness number 97, witness number 99, witness number 100, witness number 101, witness number 108, witness number 112, witness number 126, witness number 128, and witness number 131. Thank you for your time, Mr. Chairman.
So I see that there's a joint response filed. Is there one attorney arguing for the interveners?
Yes, Mr. Chairman, this is Kate Mixon. I'll be responding on behalf of all of the entities listed in our joint letter in response.
All right, please proceed.
Thank you, Mr. Chairman. As an initial matter, I would just like to note that you've heard Dominion's counsel today and in their letter filed on March 18th repeatedly style our clients along with Vote Solar, SIA, and NCSCA as subsidy supporters. I would leave it to the commission to determine how to enforce the rules of professional conduct, but would note that that is a gross mischaracterization of our position in this proceeding. And given that that's now been stated on the record at this hearing, I wanted to just take a brief moment to reiterate that our position in this proceeding is not in favor of subsidies, but rather in favor of Dominion being required to comply with Act 62. Dominion's proposal is designed to all but eliminate bill savings for solar customers. It will kill the solar market in its territory and make it so Dominion's customers are unable to use rooftop solar to lower their bills. Moreover, under our alternative proposed tariff, no subsidy would occur to solar customers. Dominion is only able to find a cross-subsidization by significantly undervaluing solar and incorrectly stating that solar customers cannot both save money on their bills and save money for the utility. As the recent Duke proceeding showed, that is not the case. Now, on to the merits of Dominion's objection and request to strike. First, it is irrelevant how any particular individual found out about the public hearing tomorrow. It is a public hearing, not a secret meeting. Act 62 provides for notice and an opportunity for public comment and a public hearing on these proposed solar choice tariffs. The issue here is whether the hearing tomorrow should serve as both a customer hearing and a public hearing. Under South Carolina Code Section 58-27-10-6, the term public is broadly defined, meaning the public generally or any limited portion of the public, including a person, corporation, or municipality. While the PSC does have notice requirements that are directed specifically at utility customers, those requirements seem intended to ensure that those most directly impacted are given notice, rather than to limit who may appear at public hearing. It appears that Dominion's objection is based on them conflating the requirements for a party to intervene in a proceeding versus those requirements for a person to participate in a public hearing. As stated in South Carolina Code of Regulations 103-804T, a party needs representation if they want to intervene in a proceeding, which includes the right to offer evidence on behalf of their party represented and to cross-examine witnesses offered by other parties. That is not available at this public hearing, and therefore an attorney is not needed. Rather, the participants in this proceeding would be more properly characterized as protestants, as defined in South Carolina Code of Regulations, Section 103-804T, and further discussed in Section 103-827. A protestant is defined as an individual objecting on the ground of a private or public interest, and Section 103-827B specifically provides that protestants are allowed to make an appearance at a hearing if one is scheduled. I would also note that the commission provides letters of instruction for filing a protest before the commission, along with a set of frequently asked questions that provides the same. As a result, Dominion is incorrect in alleging that individuals who are employees of solar companies in South Carolina may not participate. A solar company employee could easily allege both a private and public interest objection to Dominion's proposal here, and therefore they would meet the requirement needed to be a protestant in this proceeding. That does not mean those individuals are speaking on behalf of a solar company whose interests are represented by an intervener in this proceeding. Ultimately, we believe this is an issue of weight and not admissibility. So long as a party can demonstrate an interest in the proceeding, their testimony is relevant and they are entitled to testify. The commission is certainly entitled to give more weight to the testimony of Dominion customers, but that does not mean that non-Dominion customers should be excluded. Lastly, I would note that Dominion has also created a severely narrow definition for who would qualify as a Dominion customer. Dominion's position is that only the official account holder or somebody authorized to transact business on behalf of the account could speak at this proceeding, and that they have no relationship with a person who perhaps lives in a house that receives service from Dominion and may be responsible for paying all or part of the bill, merely because their spouse or roommate is the official account holder. That is an impractically narrow definition that ignores how a large number of households manage their utility bills. Indeed, I would hope that every household served by Dominion, under their definition, has made sure that the person most comfortable with public speaking is included on the account. Dominion wants to exclude these individuals because it knows or is concerned that they will speak in opposition to its proposal. We think it is for the benefit of the commission to hear what they have to say. Thank you.
ORS, do you have a position?
Mr. Chairman, we do not. Thank you.
Commissioners, do you have questions? Commissioner questions.
Mr. Chairman,
Vice Chair Belzer.
I have a question for Dominion. Mr. Gissendanner, how are you this morning?
Doing well, Commissioner Belzer.
When the motion for a public hearing was filed, I think back in January, Dominion opposed that motion, did they not? They didn't even want this hearing tomorrow, is that correct?
That's correct. We opposed the hearing and the addition of and the provision of additional notice,
Okay.
and did not believe that this hearing was necessary or required. That is correct.
Thank you very much. That's all I have, Mr. Chairman.
Chair Williams.
Commissioner Caston.
Question, I guess, for Ms. Mixon. Ms. Mixon, can you hear me okay?
Yes, I can.
What if all the time slots were occupied by people outside of Dominion service area and no customer from Dominion who resides in the service area is unable to provide testimony? Do you think this was the intent of the legislature?
No, Commissioner Caston, we don't think that's the intent of the legislature, but we also don't think that that is the situation that we find ourselves in here today. I don't recall the exact number of individuals that Dominion has requested to strike from this proceeding, but I believe it is maybe 23 or something like that, and I believe there are 170 something individuals who have requested to testify. I don't believe that there is an issue here with the number, I guess the people that Dominion is requesting to strike, flooding out all of the others that Dominion has already identified are their customers. We are not trying to exclude anybody from this proceeding. We think that it's in the benefit for the commission to hear what everybody has to say.
But again, it's a hypothetical question. Hypothetical meaning it could occur, it could not occur. I don't know. But again, what if all of the time slots were occupied by people outside of the Dominion service area and no customer of Dominion who resides in the service area was unable to provide testimony? If that scenario occurred, Do you think that was the intent of the legislature, and would you support that?
Commissioner Caston, I would suggest that there could be two solutions to that. One would be to expand the number of slots available and to hold additional hearings, or to hold a hearing specifically for Dominion customers, in addition to the public hearing that's required under Act 62.
Okay, am I understanding you to say that if that occurred, then we should have a separate hearing for just Dominion customers?
I think that could be an option open to the commission.
And what would the definition of just Dominion customers be in that scenario?
I think Dominion customer should be defined as a person residing in a household, and I guess this would just be the definition for residential, that is served by Dominion.
All right, let me ask you another question along those lines then. If you had an account in your name, whether it's a credit card, phone bill, whatever, if you had an account in your name, if someone else that might live in your house, may not live in your house, might be a relative, might not be, they might come and stay at your house, would it be okay for them to access your account or be the customer or listed as the customer?
I would suggest that that person may not be able to, for instance, access the account, but that they would be entitled to speak at a public hearing as a Dominion customer and a person who's served by Dominion. And we'll just tell you practically that that is a situation that I, as a Dominion customer, have found myself in the past, where myself and my fiance, I was the only one listed on the account. And therefore he would have not been entitled to testify despite paying for part of the utility bill.
But if it wasn't Dominion, I'm saying if you had another account with another entity, another utility, whether that's the cable company or your cell phone company, would it be appropriate, in your opinion, for someone that lived at your house to speak at a public hearing for that utility because they lived at your house and were not on that account?
I believe so. For instance, if it was a cell phone bill under my name, but somebody was provided service by that cell phone company, I would believe that they would be entitled to speak at a public hearing for that utility about the service that they are provided.
Okay.
I think we should differentiate between being able to access accounts and the ability to speak at a public hearing about the service that a person is provided. And would argue that the latter is should be a broader categorization.
Okay, thank you, Ms. Mixon.
Any other questions from Commissioner?
Mr. Chairman.
Commissioner
Bill
Powers. You have the floor, sir.
Thank you, Mr. Chairman. Ms. Mixon, as a lawyer, I never got a chance to serve on a jury, but I have served as a judge. In our position, I think we're a little bit of judge and jury in hearing things. Would that be a fair statement?
Yes, Commissioner.
And I know that juries, I've always heard them instructed that you can give whatever weight you want to a witness's testimony. You can give it little, none, or all. You can pit one witness against another. You know the whole thing that a judge charges. And a judge on a case where there's no jury has the same Wright serves as juror and judge. Is that correct?
Yes, Commissioner, I think that's correct.
Okay. Would a possible way this could be handled would be that Dominion customers would be required to identify themselves under oath, and non-Dominion customers be required to identify themselves under oath. And then we as judges and jurors decide what weight we want to give whatever they have to say.
Yes, Commissioner, I think that would be a very reasonable option. And again, that is what I noted in my statement earlier, is that we believe ultimately this is an issue of weight versus admissibility. And simply asking customers what their interest in the proceeding is at the outset could be a way of identifying Dominion customers versus those representing other interests.
Ms. Mixon, wouldn't it be proper also to do that under oath too?
Yes, Commissioner.
Okay, thank you. That's all I have.
Any other commissioner questions?
Chairman Williams, this is Commissioner Williams.
Commissioner Williams, you have the floor, ma'am.
Thank you, sir. Attorney Gissendanner, it's good to see you today, and I appreciate that you raised the letter from, was it Mr. Gopalan?
It's Mr. Gopalan, Gopalan.
Gopalan, okay.
Gopalan.
Right. As you probably know, I believe there have been a number of letters submitted in our docket system on this case.
There have been a number of letters. I would assert I actually went through or scanned them all the other night. Many of them appear to be essentially form letters. Many of them say the same thing, but Mr. Gopalan's stuck out because this was obviously not a form letter.
Would Dominion be willing to file those letters as a late filed exhibit?
I'm sorry, I'll let you finish your question.
Potentially even summarizing how many are form letters, how many are for, how many are against the case presented.
Those letters are already in the commission's files. They're filed with the commission. Dominion would not file a late filed exhibit making those letters part of the hearing. Those are inadmissible because they are not testimony under oath. I believe it's Commission Regulation 103-845 that requires that evidence be provided under
Attorney Gissendaner, we barely can hear you. If you would speak up for us, sir.
Commission Regulation, we would not file a late filed exhibit with those letters and include those in the record because that is not testimony that was given under oath. I believe it's Commission Regulation 103-845 that requires that testimony be provided under oath. Those letters obviously were not provided under oath. 827, and I would also say that 827, Commission Regulation 827 indicates that those letters are placed in the commission's file for review, but they're not evidence.
Thank you very much, Attorney Gissendanner.
You're welcome.
No further questions.
Any more questions for the parties?
Mr. Chairman, this is Commissioner Thomas.
Go right ahead, sir.
Thank you. And this question, I believe, is for Mr. Gissendanner. Can you hear me, Mr. Gissendanner?
I can, Commissioner Thomas.
Thank you. So I'm just looking at South Carolina Code Section 584020F1. And that says in part, after notice and opportunity for public comment and public hearing, the commission shall establish a solar choice metering tariff, and so on and so forth, in effect after May 31st of 2021. So to me, I'm looking at the words for public comment and public hearing To me, I don't see that limiting this to customers. Do you agree or disagree with that?
Commissioner Thomas, I would agree with you that the statute that you read makes no reference to customers. I would also submit that the public hearing occurred in February. That was the public hearing that is referenced there, and the public comment is obviously the comments that I was just discussing with Mrs. Williams that are on file with the commission. A public hearing such as we are having tomorrow is in no way required by the statute. The statute has been fully satisfied by the public hearing, and by public that means in the sense that it is an open hearing and open comments on the matter, and that was satisfied in February and by the comments that have been submitted to date via the commission's docket management system. I would say what we are here to discuss, and I would note that my opponents in their response did not argue that statute mandated that the hearing be open. They just said that it didn't limit it to customers. But I don't believe that tomorrow's hearing is required under the statute. And I certainly don't believe that the commission, that what we're discussing here today is the commission's notice. And that notice was plain that the hearing tomorrow was for Dominion's customers. And customers are people who are listed as an account holder and also people who are authorized to transact business under the account. I understood Ms. Mixon to respond to Commissioner Caston's question to say that she would define a residential customer as anyone who lived in the household. I can most assuredly tell you that my 5-year-old and my 7-year-old, although they live in my household, are not Dominion customers.
Okay. Thank you. I appreciate that. That's all I have.
I noticed that Mr. Knapp was not a part of the joint letter in opposition from the other interveners or made any representation of a position. Mr. Knapp, are you still on the line?
Yes, sir.
Okay. I'm sorry that I overlooked you. Do you have a position?
Well, if I might, first I'd like to object to the Dominion Council is referring to the interveners as subsidy supporters. I just don't think that was appropriate. The interveners, Council for the Interveners have not characterized in their proceedings as Dominion being an industry killing advocate. So I just want to make that clear. Regarding the issue at hand, I do not oppose anybody weighing in on this. I think this issue goes well beyond just Dominion ratepayers. The decision the commission is going to make is going to impact, it's going to impact everybody in South Carolina that cares about controlling climate change by reducing carbon emissions, which is driving extreme weather, it's driving sea level rise, which impacts the total economy of the coast of South Carolina. So these are the benefits of our present system for net metering that Dominion chose not to explore at all. So unfortunately, it might come down to some public hearing to inject the benefits of our net metering program today into the proceedings. So I do not oppose the introduction of others who may not be a Dominion customer. So thank you very much, Mr. Chairman.
All right. Thank you, Mr. Knapp. So a few things that I have I would like to get some insight on. I guess we can go Dominion first, the solar interveners, Mr. Knapp, and then ORS. So I think today was the first day that I heard the the two words put together, subsidy supporter. Can anyone tell me if that term or phrase has been used before this point in this docket, in the case that we had before we had this that we held before we had this oral argument? I'm trying to figure out where did that phrase come from. Subsidy supporter. Dominion?
Mr. Chairman, this is Matt Gissendenner. We used that phrase in our reply. I would simply state I understand that Mrs. Mixon takes issue with that phrase. However, the company stands by that. The argument that the other interveners are making is while they are trying to say that they are not for the subsidy, they are, as we pointed out in our testimony at the hearing in our arguments and on cross-examination of their witnesses, what they are arguing is that the avoided cost would need to be greatly inflated, and by inflating the avoided cost, they therefore avoid a subsidy. The problem with that argument is that when you inflate the avoided cost above what the avoided cost actually is, all customers, Dominion has to pay that cost, and then Dominion recovers that cost from its customers. So either way, the customers would be either under the status quo as it is today, or under the plan that the interveners are offering. They are, in fact, calling for NEM to be subsidized.
And I understand the argument. I'll save my question for you after I hear from the others. Attorney Mixon?
Yes, Mr. Chairman. I note that term, as Mr. Gissendenner said, was first used in Dominion's March 19th response to our reply to their letter requesting to strike individuals. And we think there's a fairly clear difference between them stating, for instance, that the interveners' proposal would cause a subsidy, and simply calling us solar or subsidy supporters. We, in our response, refer to the company by their name. They're Dominion Energy South Carolina, and then we discuss the merits of their proposal and the impacts that we believe that it would have. I think there is a difference between those two positions.
Mr. Chairman, Taylor Spear for Alder Energy. I'd ask to be heard very briefly on this issue.
Yes, please.
Thank you, Mr. Chairman. I just want to add, for the purposes of non-residential customer generation, how disingenuous this term is, considering that Dominion has testified under oath in the proceeding that medium commercial, large commercial, and industrial commercials, customers rather, do not present a cost shift at all in Dominion territory. And that's all I have to add. Thank you.
Office of Regulatory Staff.
Mr. Chairman, this is Kate Mixon. If I may add just one other point, which is just that, again, we strongly disagree with Dominion's characterization of our position as supporting a subsidy, and indeed our alternative proposed tariff would not cause any subsidy to solar supporters. Thank you.
Office of Regulatory Staff.
Thank you, Mr. Chairman. We have no comment on the use of the phrase subsidy supporters. I believe, as others have stated, the first we heard it or read it was in Dominion's filing last week.
All right. Mr. Napa, I think you already made your position known regarding that phrase or term.
Mr. Chairman, if I may just add something, part of my taking offense to the terminology is that I think that testimony presented at the hearing was very clear. There is no cost shift going on at the present time. You know, maybe sometime years down the road, if the commission ever approves a rate hike, would that happen? So it's not going on now, so that's what that this whole thing is simply a way of framing the issue to influence the commission and the public, to be honest with you. So thank you, Mr. Chairman.
Attorney Gissendaner, the reason I'm spending so much time on this term, it sounds, I could be wrong, but it sounds like I guess what could be known as a trigger word. And I would ask in proceedings before the Public Service Commission that all parties treat their opponents with dignity and respect. And I think you could make your point about your opponent's position without using the phrase subsidy supporters. Am I wrong? Could you not? You're muted, Attorney Gissendaner.
Sorry, Mr. Chairman. Of course, we use that term to refer to our opponents collectively based on our arguments that we put forth at the hearing, where we have consistently maintained that they are arguing to preserve a subsidy. We've argued that a subsidy exists. Contrary to what Mr. Knapp just said, the testimony at the hearing on behalf of Dominion was that customers are in fact paying a subsidy today. And also contrary to what Mr. Knapp said, although they certainly did not refer to us in a motion as the industry killing advocates, they certainly have made that point. Mr. Knapp has made that point in more than one newspaper editorial and more than one statement at the commission. So I would simply respond that yes, there are a number of ways that we could have defined that collective group. I did not view that as a trigger word, that the issue of a subsidy or a cost shift is the central issue in this proceeding. And so I thought that it was entirely appropriate to use that term to define the group in an argument, but certainly did not mean any disrespect and certainly did not consider it to be a trigger word.
Mr. Chairman, since I've been name checked here, let me say that if Dominion Energy wants to say anything they want to in the public realm outside of this hearing, they're certainly allowed to do that, as I am also. But within this hearing, I think there are different rules that apply. So I just wanted to make that clear, and I will emphasize again, their own witness from Dominion says that passing this solar choice tariff now will not accrue any benefits financially to any customers in South Carolina, possibly for years and years to come. So thank you, Mr. Chairman.
Mr. Chairman, I also recognize that Mr. Knapp has the ability to say whatever he wants to say, and I will just let the testimony speak for itself. And again, I would also say that no disrespect was meant. I clerked for the Fourth Circuit Court of Appeals and have read numerous briefs and attended numerous arguments, and parties all the time use persuasive techniques to define their opponents. And as I said, the subsidy issue is the central issue in this case, and I think our use of the term was entirely appropriate, given, as I said, that as Ms. Mixon herself just argued, that they are asking that the way that they say that they are not supporting a subsidy is that the avoided costs be inflated much higher than it is today and above what the avoided cost actually is. And when you do that, customers still pay that avoided cost, and therefore they are still subsidizing the rooftop solar industry. So I thank you for pointing that out and letting us know your thoughts. And again, that was certainly not my intent. And I certainly don't view it as a trigger word.
I understand, but you think describing the solar industry in South Carolina in a motion before the Public Service Commission as subsidy supporters is appropriate? Is that and persuasive? I just want to make sure I understand.
It's certainly persuasive. A persuasive use of the term that is used in briefs before courts at all levels, and it is also exactly what the industry is arguing for in this case, and that is to maintain essentially the current structure and continue to support rooftop solar through a subsidy that is paid for, or a cost shift that is paid for by the other 750,000 customers of Dominion Energy.
Okay. Attorney Gissendaner, could you tell me how the solar industry discouraged and ensured average customers won't participate in the public hearing tomorrow?
Yeah, I'll go through that again. Well, first of all, and I'll take us back to the very beginning when this hearing was initially noticed. That was on January 14th, I believe. If you go back in the commission's records, the ORS made a filing and asked that the notice include a statement of the benefits to all customers, both the participating customers and the non-participating customers. The commission staff requested that Dominion provide them with those statements. We did. You'll notice in the first notice that was issued, there is a statement. It indicates that the information was provided by Dominion Energy. The commission routinely, in its notices, indicates that the company states certain things about its filing or about its tariff. After that original notice was issued on January 14th, Vote Solar and the other parties objected and proposed new language that essentially erased any reference to the benefits of the company's proposal to all customers, to the non-participating customers specifically. The commission staff over Dominion's objection granted the revisions of Vote Solar, and the company was clear at that time that it appeared to the company that Vote Solar and the other commission staff, Vote Solar and the other parties were interested only in providing notice to the participating NEM customers and were intent on keeping non-participating customers in the dark about this proceeding. And that was in so the notice now, as it states, what are the benefits, simply say that the notice is intended to comply with SC Code N 584020. And I think you would be hard pressed to argue that a non-participating customer would have any idea what that means. So from the very beginning, we argued that it was their intent to keep non-participating customers in the dark about this proceeding. During the course of this proceeding, we notified the commission as early as possible that there were, as soon as we became aware of it, I believe in the preliminary matters of the hearing itself, I informed this commission that there were a number of industry advocates who had signed up to testify who were not customers, including 4 individuals who are not customers who are affiliated with Sunrun. And then I think, as you saw in our supplemental reply that we filed the other day, Mr. Grinstad of Sunrun indicated that Sunrun and its allies are working tirelessly to ensure that this doesn't, that the company's proposal is rejected. I'm not, obviously the allies are here before you, and we have, so I would just argue that the fact that there appears to be a concerted effort to fill slots early on, to fill slots with individuals who are not customers of Dominion but are affiliated with the solar industry. That is clearly an effort to flood the commission with individuals testifying on behalf of the solar industry, and then the effort to keep the notice from making any reference to the benefits to non-participating customers as ORS requested is another effort to ensure that by the solar industry to ensure that non-participating customers are kept in the dark about what is going on in this docket. And that's the basis for the company's statements.
Isn't it true that Dominion sent the notice you referenced? I guess the original and the revised. I know at least the revised to all of its customers.
We did. We sent the revised notice to its customers. The original notice was objected to by Mr. Cully. I understand he's not with Vote Solar and is now with Sunrun, but it was objected to by Mr. Cully, and the other parties provided revisions that essentially stripped the notice of any reference to the benefits to non-participating customers, and those revisions were accepted over Dominion's objectives, and Dominion provided the notice as it was required, the revised notice as it was required to do to all of its customers. That's correct.
So that,
and what I'm simply saying is that when it talks about the benefits to customers at the bottom of the notice, and it says that these are the benefits to participating and non-participating customers, as a non-participating customer, you would be hard pressed to see how this impacts you or what the benefit is.
Yeah, that's what you're saying now, but I want to make sure I understand why you said the solar industry discouraged and ensured average customers won't participate in the hearing tomorrow. Now, Dominion Energy sent the revised notice to all of its customers, correct?
That's correct.
How did the solar industry prevent that notice from going out?
No, that's not the argument, sir. The notice went out. What I'm saying is that the notice does not inform, as compared to the original notice, the notice that went out does not inform non-participating customers of how they would benefit from the company's proposal, or even that there's any reason that they really ought to even be interested in the proposal itself. And so then what happened was you had people signing up, a majority of the people, I think at the time of the hearing, I don't remember how many had signed up at the time, but you had about 30% of the people who had signed up at the time of the hearing. And again, we don't know, what people are going to testify to tomorrow, but you had 30% of the people who had signed up at the time of the hearing, and I believe 30% at the time that I filed my response were individuals that were associated, that were individuals who were not customers. And many of those individuals were individuals associated with the solar industry and who were not customers. And there appears to be a planned effort on behalf of the industry. And obviously we have contacts. I believe there was testimony at the hearing that the company talks to stakeholders on an ongoing basis, and we are informed that there was an effort to ensure a number of people showed up, and part of that effort included obviously having people sign up who were not customers but yet were affiliated with the solar industry. And when they sign up, that prevents other people who may have testified from taking that time slot.
How many time slots does the commission have available?
I think there are a number of time slots. I think you have 4 hours. I guess you've got 20 an hour, and then another 4 hours at night. So what is that, 160? Maybe minus some breaks. I don't know. You've got 176 people signed up so far, and you continue to add. But again, of
And
course,
that's the-
now we're at
And that's
now we're at 10 o'clock. Now we're at 10 o'clock at night, and I don't know when certain people can testify. Mr. Gopalan obviously said, you know, and I was very clear that I was not arguing that Mr. Gopalan could have testified anyway, but certainly Mr. Gopalan indicated that he couldn't testify at the date and time. Certainly, when you have some people may be able to testify in the morning, perhaps they can't testify at night, and when you have the industry signing up 30% of the witnesses for the early morning hours at one point were industry witnesses or non-customers. And then you also have certain witnesses who are customers and who are industry participants.
And so essentially what you're saying, it's important for non-solar user customers to testify in this proceeding.
I think it's important for them to at least have the opportunity to testify if they want to testify. And I think that, you know, obviously you want, I think the commission likes for, and I've heard you all say that it's important for all voices to be heard. And as far as customers go, all voices is not just the 11,000 voices of those who have solar, but also the 750,000 who don't.
Right. And so you believe that it's important for your customers who are not solar users to testify in a proceeding like the one tomorrow?
I believe it's important that they have the opportunity to testify.
I got you. And that's why you always advocated for this hearing to take place tomorrow. Is that true?
We advocated that this hearing was unnecessary tomorrow under the law, and that this was we advocated that it was not necessary.
The
commission disagreed.
You advocated that it was necessary because it's
we advocated that we advocated that
or am I misunderstanding?
No, sir. We advocated that the hearing was not necessary. The commission decided that they wanted to have a hearing, and if you are going to have a hearing for customers, then we think that it is important for all customers' voices to be heard. This was a hearing that was suggested and called for by Vote Solar, who argued that there was insufficient notice and was upset that the company had not filed an application, despite the fact that the company was not required to file an application in this docket. We don't believe that this hearing tomorrow is required under the law, and obviously the commission decided that they wanted to hear from the company's customers, and when the commission in its notice indicated that they wanted to hear from the company's customers, we assume that the commission meant that it actually wanted to hear from customers and not advocates for the solar industry, not the public at large. It wants to hear from the company's customers. That was what the notice said.
So that was the assumption that you all made. That Dominion.
Well, it's not the assumption. It's the words in the commission's notice itself. This is a hearing for Dominion Energy customers.
Well, it's interesting you bring up the notice. So Dominion sends out the notice. The commission doesn't send it out, right?
The commission provides the notice and requires that Dominion send the notice out.
Right. So a notice is never sent from the commission. It's always sent from Dominion, right? Or any utility.
Correct.
Is that correct?
That's correct.
Okay. And so
the commission go ahead.
And so, considering the fact that the commission doesn't send out notices, wouldn't it make sense for the utilities notice to be sent to its customers?
Yeah, we do send the notice to our customers. That's who we send it to.
But that's not necessarily a limit on who has the right or opportunity to participate in a hearing, though, is it?
Mr. Chairman, when you notice that the hearing is for Dominion Energy customers, I think that's a limitation on who can participate in a hearing. And I also think that just the general principle of standing is a limitation on who can participate in a hearing. Obviously, when there is a limitation on who can participate as a party of record, the party of record is required to have standing and the general rule that allows for members of the public to testify, that rule was not intended to eliminate the effect of standing. It simply allows individual witnesses to testify and provide the commission with evidence without having to go out and hire an attorney. But certainly, it doesn't intend to allow entities or individuals who would not otherwise have standing to be a party of record to then come and introduce evidence into the record. And for that reason, I strongly disagree with, and the company strongly disagrees with the statement of the other parties that this question before you today is a question of weight. This is plainly a question of admissibility.
So to cure the issue with the notice, the next time the commission directs a utility to send out a notice in a proceeding like this, it will cure any issues you have or the company has by saying that the notice is for any and all parties that wish to address the commission, or words to that effect. Would that cure your issue?
You could, Mr. Chairman. I think the question you're asking is, and you can, if you'll allow me to rephrase it, if we didn't have the statement in the notice, would we be here today? If we didn't have the statement that this is a hearing for all customers, would we be here today? And I think that the company would argue, even if the notice did not say that this is a hearing for all customers, or if it went further and said that this is for everyone to testify, the company would still be here today arguing this, because again, all members of the public do not have standing or an interest in a proceeding in the Dominion Energy South Carolina case. Its customers have an interest, but non-customers do not. And so the company would argue that it would be inappropriate to hear testimony in a proceeding on behalf of Dominion Energy from somebody who could not satisfy that standing requirement.
All right. Thank you for putting your position on the record and making it clear for me. Do we have any more questions for the
Chairman Williams?
Commissioner Caston?
I don't recall whether it was Mr. Knapp or Miss Mixon. Let's see. I think talk about, or maybe it was Mr. Spears. I can't recall, but I think there is no cost shift has been mentioned twice. You're probably going to have to help me out if it was Attorney Spears, Mr. Knapp, or whom, that there is no cost shift. Has that issue been decided yet? I guess Mr. Spears or Miss Mixon.
Yes, Commissioner Caston, this is Kate Mixon on behalf of CCCL and Upstate Forever. And no, that issue has not been decided yet. And to address Mr. Gissendanner's argument a moment ago, that was the basis for Vote Solar and other interveners' revisions to Dominion's notice. Their initial proposed notice said specifically that their proposal would reduce costs for all customers who didn't use rooftop solar, while allowing those customers to self-supply power without penalty. And that is a central issue in this proceeding. And so we did not think that it was appropriate for Dominion to characterize its proposal as such in a notice to the public. We simply asked that the notice state what the proposal would do, rather than provide commentary. on whether it was good or bad. And we felt that making the revisions that we requested were entirely appropriate for a notice that would go out to all of Dominion's customers. I would also note that the notice did state that the proposal, and this is at the bottom of the first page of their notice, that we're requesting commission approval for a new rooftop solar rate designed to reduce costs imposed upon all customers who do not utilize rooftop solar. Again, on page 2, it says the proposed tariffs are intended to eliminate to the greatest extent practicable any subsidy currently paid for non-rooftop solar customers. And so it is not true that the revised notice that was sent out to Dominion's customers would not provide any notice to non-solar customers that they may want to testify at the public hearing tomorrow.
Okay, so am I understanding, and I don't remember the exact terminology that folks use, but am I understanding that I think it was something along these lines, the subsidizing industry supporters is not okay verbiage to use or should be used? Is that part of what I'm hearing now?
I'm sorry, Commissioner Casson, I'm not sure that I fully understand what you're referring to.
Well,
Could you please repeat your question?
I'm sorry. I've heard a couple of different things, and I'm really just kind of trying to discern, what's okay to say, what's not okay to say, and I'm not arguing for either. But I understand there was some consternation about, I think, Attorney Gissendanner's statement talking about subsidizing industry supporters. I think something along those lines, but I also heard someone mention industry killing. So is it your opinion that one of those is okay to consider and one of those is not okay to consider as far as phraseology? I'm just trying to determine what's good phraseology, what's not.
Sure, thank you, Commissioner Castor. I think I understand your question. The issue that was raised earlier was that Dominion styled all of our clients, which includes say CCL and Upstate Forever, along with 3 other organizations that joined in our letter responding to their request, and they referred to us specifically as subsidy supporters throughout that letter, and again earlier in Mr. Gissendanner's comments earlier. Whether or not there is a subsidy is a central issue in dispute in the proceeding, and our client's support of a subsidy, that is something that we strongly disagree with. Our argument is that Dominion's proposal is contrary to Act 62, that it would impact the solar market, and that our alternative proposal would not cause any subsidy to non-solar customers, and that if the benefits of solar were properly quantified, that there would be no subsidy at all. But rather than Dominion saying, in our argument is that the environmental intervener's position would cause a subsidy, they instead styled us as subsidy supporters throughout the entirety of their letter, which we feel is inappropriate and different than saying Dominion Energy South Carolina's proposal would have a severe disruption on the solar market.
But it didn't say disruption. I guess I'm trying to understand what fair is. I mean, because I'm certainly hearing different sides of what they think fair is, but
Yes,
Dominion,
Commissioner Caston, I guess,
well,
I apologize.
Dominion is in essence saying, rightly or wrongly, because it hadn't been determined yet, that it is subsidizing industry supporters. Of course, the argument from you and others is that there is no cost shift yet to be determined. And the argument is also not been determined that if this occurs, it will be industry killing. I guess what I'm basically saying is it's kind of like what's good for the goose is good for the gander, in that, okay, it hadn't been decided yet. You're saying it's inappropriate for the utility to say such as this. But on the other hand, it's okay for the others to use maybe terminology that might be considered prejudicial by some too. So I guess I'm trying to discern, is one more right than the other, and why?
Our Commissioner Caston, I think our position is that Dominion's state, like it's calling us solar or subsidy supporters, was not an argument, that it was simply name calling, and that if they wish to discuss the merits of our arguments in the proceeding, they could call us the environmental interveners or joint interveners, and then state what their position about our proposal is. That is what we have done for them. We called them by their name, Dominion Energy South Carolina, or the company, and then stated our argument as to what the impact of their proposal would be. We did not call them, I think Mr. Knapp said earlier, industry killer throughout our briefs or our testimony in the proceeding. We call them Dominion Energy South Carolina. And we think there is a difference between mischaracterizing our position and frankly calling us a name and arguing against our position here.
Okay, thank you. Attorney Denson Danner, may I ask you a question?
Commissioner Caston, well, before we get into that line of questioning, I'm getting some notes that we need a 5-minute break, 10-minute break. We're in recess until 10:36. All right, we're back on the record in docket number 2022-29E, or arguments, excuse me, or arguments in Dominion Energy South Carolina Incorporated's establishment of a solar choice median tariff pursuant to South Carolina Code annotated section 58-40-20. We're here on Dominion's motion to strike witnesses. Let's take roll. Here in the hearing room, we have Commissioner Caston, Vice Chair Belzer, and Chairman Williams. Joining virtually, we have Commissioners Powers, Thomas, and Williams. Commissioner Caston, the floor is yours, sir.
Thank you. Mr. Dissendanner, can you hear me okay?
I can, Commissioner Caston.
Good. Would you be okay with whomever testifies under oath to declare whether they are Dominion customers or not, or have rooftop solar or not?
I think that that certainly that is relevant as to whether they are a Dominion customer or a non-Dominion customer, and we've certainly asked that customers be stricken unless they testify under oath that they are a Dominion customer. I also think that it would be highly relevant for them to testify as to whether they own rooftop solar or do not own rooftop solar. I expect that the testimony that we would hear from Dominion customers would typically split into three camps: those who have rooftop solar and are opposed to the proposal. There may be some other customers, perhaps a smaller percentage, who do not have rooftop solar, but are generally favorable to the positions of the Conservation League and the Alliance for Clean Energy. And then there would be the vast majority of the 750,000 customers without rooftop solar who would likely not feel that they should continue to pay for other customers' rooftop solar. But with that said, I think that both of those questions would be good questions. However, the company does object to non-customers being allowed to testify at a proceeding for the company's customers, and we assert that non-customers do not have standing to testify or to provide evidence, and we think that that's an issue of admissibility, not a question of weight. So I would agree with you, Commissioner Caston, that those are both good questions, and certainly given what we know about who has apparently signed up to testify, that it would be appropriate for the commission to require individuals to testify as to whether they are in fact a Dominion customer. And again, that standard is, are you an account holder, or are you listed as a person authorized on an account?
So I'll take that answer, and if I'm taking it incorrectly, but whomever testifies under oath, if they declare whether they're a customer or not, or rooftop solar or not, you have no problem with those questions being asked of whomever testifies?
I have no problem with those questions being asked of whomever testifies, and I'm just stating that if the answer to the first question is that the individual is not a Dominion customer, the company would object to that testimony being admitted into the record.
Okay, do you believe the commission is able to objectively listen to facts and arguments and weigh those facts and arguments?
Yes, certainly. The commission, as a trier of fact, is allowed to objectively listen to testimony and weigh that testimony. However, there are before you get to a weighing of the testimony, there is the question of whether the testimony is in fact admissible. And what the company is arguing with respect to non-customers is that the testimony is not admissible.
All right, Chairman Williams, if I may I ask those same questions of Attorney Mixon?
Yes, sir.
Are you there, Attorney Mixon?
Yes. Commissioner Caston.
Would you be okay with whomever testifies under oath to declare whether they are Dominion customers or not, or have rooftop solar or not?
Yes, we would have no objection, to that.
And same question too, do you believe the commission's able to objectively listen to facts and arguments and give appropriate weight to these facts and arguments?
Yes, Commissioner.
Thank you, Ms. Mixon. Thank you, Chair Williams.
Any other questions for the parties? All right, hearing none.
Mr. Chairman,
Vice Chair Belzer.
because this hearing is tomorrow, I'm not sure if the chair wants to entertain a motion from the bench. I know typically we take these under advisement, we rule on them in a commission business meeting.
I'll hear your motion.
Okay, thank you. Mr. Chairman, at this time, I move that the commission deny the motion of Dominion to strike witnesses from the public hearing list.
All right, after hearing Vice Chair Belzer's motion, is there any discussion?
Mr. Chairman, if I may.
Vice Chair Belzer?
First, I would like to thank the parties for the pleadings that were filed. Well, I'm calling them pleadings. The letters, the responses, the replies. I appreciate the detail that the parties put forth. I went through them a good bit over the last few days. And I went back to the notice, and I looked at the notice very carefully, and I note that in the title it says Revised Notice of Virtual Public Hearing. It says, and then down a little bit it says, please take notice that the commission has scheduled a virtual public hearing. In the bulleted portion, it does in the first bullet, as Dominion has emphasized, says this is a hearing for customers of Dominion Energy, South Carolina. And then the next bullet says public witnesses must be sworn in before presenting their testimony. And in the fourth bullet, there's a reference to permit all interested witnesses. In the next section where the date of the hearing is listed, and there are two enumerated paragraphs, and in the first one it says, any person desiring to testify as a public witness. So it does appear that there is some ambiguity in the notice as to who may sign up. That's part of my motion, that's part of my reasoning to move to deny. But in addition to that, this ambiguity that there could be some confusion as to who is allowed. I do note that the notice does not say that it's limited only to customers of Dominion. So that's one ground, but I do believe that it is incumbent upon the commission to hear from as many interested persons as possible. And when we look back at Act 62, and in particular the section that we're dealing with under 58-40-20, there are three things that we need to be considering because it states it is the intent of the General Assembly, and I'm going to paraphrase here, to build upon the successful deployment of solar generating capacity through Act 236, avoid disruption to the growing market, and require the Commission to eliminate any cost shift to the greatest extent practicable. So there are several competing interests there that we need to consider. And that's part of my reasoning for thinking that we need to hear from as many diverse views as possible. But it is also the purview and the responsibility of this commission to weigh each witness's testimony, giving due regard to their interest wherever those interests may lie, and to determine what weight, if any, to give to that testimony. And for these reasons, I make the motion to deny the motion to strike witnesses from the sign-up sheet. Thank you.
Any more discussion?
Vice Chair, Chairman Williams.
Yes, Commissioner Williams, you have the floor, ma'am.
Thank you. Vice Chair Belzer, I appreciate your motion and wonder if it would be appropriate to have a friendly amendment that, or just an agreement that tomorrow we will very clearly ask those parties testifying to indicate if they are Dominion customers as they define it, and then I guess that's my question, is whether we will clearly ask for Dominion customers to identify themselves so that we understand and can listen to them with that in mind.
Commissioner Williams, commissioners are free to ask questions of any of the witnesses testifying. Certainly, commissioners can inquire. Parties can too. Dominion has the ability to ask a witness if they're a customer. The interveners can ask. Anyone can ask those questions. So, I don't know that needs to be part of the motion, but anyone participate, any of the parties or the commissioners that are participating in the hearing can ask those questions.
I appreciate that. I think I'm asking because the few public hearings that I've participated in, those testifying have been asked to identify whether they're customers of that particular area. And my guess is that somewhere between around 50 to 75% of them do indicate whether they are, but not all do.
A lot of them will indicate in their testimony, but I mean, we can certainly put that in the instructions. I have no problem with that.
I think that would be very helpful.
I think we can instruct staff in the instructions to ask that.
Chairman Williams and Commissioner Williams.
Commissioner Caston.
Along those lines, I appreciate Commissioner Williams asking that. I guess for expediency's sake, if it would be appropriate, whether at the time they're sworn in or as part of the instructions, is that we include not just that, are you a customer as defined by, I guess, Dominion, but whether you are a participant or owner of rooftop solar or not, both of those things, if that's okay.
Again, those questions can be asked of the witnesses at that time.
Well, again, what my only thought was, or concern was, if we have 180 or 200 or whatever, and just for expediency's sake, so as to not ask that of 180 or 200 folks, if it was possible to kind of get that out of the way right at the beginning. I guess that's the question I have. I don't have the answer to that, but just.
Well, I think mechanically what happens, and I'll ask one of the staff members to correct me if I'm wrong. The commission staff calls a witness or two, has them in the queue, and then they testify once we call them. So if we ask them before, so if we said at the beginning, please state your name, your street address, whether or not you are a Dominion customer or if you are a solar participant. If we stated that at the beginning, my understanding is that everyone is not viewing and observing at the beginning. They're waiting to receive a phone call from our staff. And if our staff were to ask those questions before they got on the record, then that information wouldn't be on the record. And so I think because we are trying to accommodate so many people during the COVID-19 pandemic, efficiencies have been lost in that. And I think to get the information on the record, what's going to happen is that each of those 170 plus witnesses are going to be asked the same question. I don't know if there's a way around that or not. If there is, I would ask the staff to let me know.
Thank you, Chairman Williams.
Mr. Chairman, I would just note that a lot of the folks that we have calling in as witnesses, even though they're not appearing in the hearing room and with a lot of eyes on them, you can tell that they're still nervous about testifying, and they're having to remember, please state your name, please state your street name and town, and to add these others. I mean, even if the staff were to give them this litany of things that they need to state at the beginning of their testimony, people are going to forget. They're going to skip something. So if this is information that the commission wants on the record, if it doesn't come out in the testimony, I think it's just incumbent upon somebody to jump in and just ask the question. I think that would help move things along as long as we're prepared to go forward, somebody to ask the question. So I just know that even before COVID, when we were doing live hearings and instructions would be given to witnesses, please state these things at the beginning of your testimony, people are nervous and they just forget. So to the extent that we need to help prod that information along, we just need to do it. It's not that difficult, and it just takes a few seconds if we're prepared to ask the question succinctly. Thank you.
All right. So Commissioners Powers and Williams, it seems, from what I'm hearing, it seems that the issues brought forward have been addressed and will be addressed during the hearing. I think it goes without saying that we're going to be here for a while. I mean, it's just a part of the gig. And not only that, it's a part of doing it right and ensuring access to the commission. So I really don't know any way to get around that other than taking the time to give every witness opportunity to testify. But I want to make sure that your concerns are adequately addressed and before we move on in discussion.
Yes, sir. Thank you.
Commissioner Williams?
Yes, sir. I think that I understand all of the challenges of testifying. I think if staff can try to ask folks to include that information, and we can certainly ask where it's not given. Is that appropriate?
Yes, ma'am.
Okay. Thank you.
All right. Is there any more discussion on Vice Chair Belzer's motion to deny Dominion's request to strike witnesses? All right, hearing none, we'll move to a vote, starting with District 1, Commissioner Williams.
Aye.
District 2.
Aye.
Vice Chair Belzer. Commissioner Caston.
Aye.
Commissioner Thomas.
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries. We're adjourned. Oh, I'm sorry, ladies and gentlemen. Are we off? Yeah, no, I'm sorry. There's one housekeeping matter that needs to be addressed. before we adjourn for the day? Attorney Stark?
Thank you, Chairman Williams. Chairman Williams, there is one housekeeping matter regarding the transcript and transcript request for the public hearing that is largely the underlying context of this oral argument. And I would ask the parties, and two of you have responded now by email, but I would ask the parties at this time if they intend to request an expedited transcript of the public hearing scheduled for tomorrow.
Mr. Chairman, this is Matt Gissenander on behalf of Dominion Energy. We do not plan to request an expedited transcript.
Mr. Chairman, Peter Ledford on behalf of NCSEA, we do not plan to request an expedited transcript.
Does anyone expect to request a expedited transcript?
Mr. Chairman, Taylor Spear, Alder Energy. I'll have to check with my client on that, but I doubt that's going to be the case. I'll happily respond to Attorney Stark via email as soon as I'm able to get in touch with Mr. Zimmerman.
Mr. Chairman, this is Kate Mixon. We saw that request go through and have not had an opportunity to confer on that, but we will respond as soon as possible this morning.
All right.
Mr. Chairman, this is Bess Duran for Vote Solar. We do not need an expedited transcript.
Okay.
Thank you.
Thank you. All right. Attorney Stark, are you good to go? All right, ladies and gentlemen, we are adjourned.